So the general topic today is how the Constitution keeps up with the times. And what I'm going to do is talk about the Fourth Amendment and the case of United States versus Jones and how it does or does not keep up with the times. I'm going to give you a brief history of the Fourth Amendment and then talk about the Jones case. The text of the Fourth Amendment says that it protects the people, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fourth Amendment also says that the police can get a search warrant if they think they have probable cause to believe crime has been committed, and they do that by going to a judge and filling out an affidavit that says why they think a crime is committed, and then the judge will authorize the search. And the general rule under the Fourth Amendment is that police are supposed to get a search warrant. And if they don't get a search warrant and they conduct a search, then the search is unreasonable. But the issue I want to focus on today is what constitutes a search and seizure and explain how that has evolved over time. The early cases, and by early I mean the 1930s, 40s, and 50s, the early cases said that it was only a search if the police physically penetrated the premises. In other words, there had to be some kind of trespass. And there were some examples of that. One example was there was a case where the police used what was called a spike mic, which they put a spike into the wall so they could hear the conversation in the next room. And the court said, yep, that's a search because that's a trespass. But the police got clever and they said, well, instead of using a spike mic, they went outside and they attached a device to the telephone wires that were outside the house, and they picked up the conversation there. And the court said, well, that's not a trespass, so that's not a search. So in 1967, the court decided a case called Katz versus the United States. Katz was a bookie, and Katz made his bets by using a public telephone booth, and the police were onto Katz, so they attached a microphone to the exterior of the telephone booth in order to pick up his calls. And so the case got to the United States Supreme Court, and the issue was whether or not that was a search. And under the prior cases, of course, it was not a trespass because they hadn't gone into the phone booth, therefore it was not a search. Well, the Supreme Court said that the Fourth Amendment protects people, not places. And it protects people when they have what's called a reasonable expectation of privacy. And the court said Katz had a reasonable expectation in the phone booth that his telephone conversation was not going to be transmitted to the government or to the entire world. And so it was a search, which means not that the police can't get Katz's, can't tap his phone, but they need to get a warrant before they can do so. And after Katz, courts in the trenches, like our court, applied the reasonable expectation of privacy test. In one case, the police put a beeper inside a drum of, it was actually chloroform, that was used in the manufacture of chemicals. And they followed the beeper as it was in the car around here and there, and they trailed the defendants, and eventually the beeper got to the house and they found out where they were making the drugs. And the rule that emerged, or seemed to emerge from that case, was that as long as the beeper was tracking public movements, that's no problem, because the police could be observing these folks. But once the beeper got into the house, that's a problem, because the house, you know, is your castle. And in another case where the police used a heat sensor, they put it across the street from a house, and they were trying to figure out how much heat was being generated from the house because they were, I think they were growing marijuana in there, and they picked up the heat sensor from across the street, no physical penetration, and it's a house constitutionally protected area, and the court said that that was a search. So along comes Jones. Jones was a big drug dealer in D.C., and he had a nightclub, and they put a camera outside his nightclub so they could pick up the people who were coming in and out of his nightclub. They put a wiretap on his cell phone of all his buddies, which, you know, sounds kind of easy, but if you're a big drug dealer, you don't just have one cell phone. You have 3 cell phones, and then you change them every day. So it was a challenge for the government to wiretap the cell phone, but they did. But that wasn't enough, so they put a GPS tracking device on the undercarriage of Jones's Jeep. And they tracked him for 28 days. And the GPS data that they had led him mostly around Maryland and D.C. and it led the police to what was called a stash house, where the police eventually recovered $850,000 in cash and 97 kilos of cocaine. So the issue before the Supreme Court was whether or not this constitutes a search, putting this GPS device on the undercarriage of the Jeep. And Scalia's opinion for the court recites the history of the Fourth Amendment, and in fact, he goes back to a 1765 English case where it said that if you walk on somebody else's land, even if you don't damage the land, that that's a trespass. And he said that this reasonable expectation of privacy test from cats that you all thought was the only test for the Fourth Amendment is not. That the cases involving trespass still survive, and that cats is one way of looking at it, but another way of looking at it is whether or not there was a trespass. And he said that putting the GPS device on the undercarriage of the Jeep was a physical intrusion on a constitutionally protected area, because a car is, an effect, and therefore it violates the Fourth Amendment to put it on there without a warrant. In a separate opinion, Justice Alito, Scalia's usual best buddy on the United States Supreme Court, said that the court's opinion strains the language of the Fourth Amendment and is, quote, highly artificial. He said that cats actually did away with all those trespass cases, and that we don't look to 18th century property law in order to decide Fourth Amendment cases. But he also says, and this is what makes the case very interesting, he also says that in this case, putting a GPS device on a car and tracking it for 28 days was unreasonable. And therefore, it violates the Fourth Amendment and violates a reasonable expectation of privacy. So the bottom line is that all 9 judges found that the police conduct here violated the Fourth Amendment, and that not having a valid warrant to install the device violated the Fourth Amendment. Since Jones, there's been at least one federal court of appeals, the Sixth Circuit, that said there's no reasonable expectation of privacy in the data that's given off by your phone. Therefore, they didn't need a warrant to put to track the person. And the New York Times wrote an editorial saying that this is even more invasive than putting a device under the car, because you track a person with a cell phone. It's not only where they're driving to, but it's where they are in the house, where they're going to the doctor, whether they're going here, whether they're going there, that it can be a good deal more invasive. And they urged the Supreme Court to take the case and to reverse the Sixth Circuit. In any event, it's an interesting line of cases because it really shows how the Constitution has evolved over a fairly long period of time in an effort to keep up with technology.